Today, the United States Supreme Court gutted what was left of the Voting Rights Act, 6-3. A Louisiana case, a second-majority black district, struck down. If you want to know what happens next, you don't need a forecast. You need a history book. Justice Samuel Alito wrote for the majority that, quote, "The Constitution almost never permits the federal government or a state to discriminate on the basis of race." He used that sentence to strike down a map drawn to give black Louisianans a second voice in Congress. In a state where black voters have spent 160 years being shot, terrorized, and legislated out of the franchise. Justice Elena Kagan dissented. She wrote that plaintiffs trying to prove racial vote dilution will now find it nearly impossible to win in court. Within an hour of the ruling, Florida's Republican legislature passed a new map projected to net them 4 more House seats. They were ready. They had been waiting. Rewind 150 years. Between 1867 and 1877, more than 2,000 black men held public office in the American South. 16 sat in the United States Congress. 2 served in the U.S. Senate. They built public schools. They wrote new state constitutions. They created the South's first integrated democracy. They knew exactly what they were doing. An Alabama freedman testified to Congress in 1871. They told us if we voted, we would be killed. Some of us voted anyway, some of us were killed, but the ones who lived kept voting because we understood that the ballot was the only thing standing between us and slavery. The ballot wasn't a civic ritual, it was an act of war. Easter Sunday, 1873, Grant Parish, Louisiana. 150 black men gathered at the Colfax courthouse to defend a Republican government they had legally elected. A force of 300 armed white men, former Confederates, White League members, surrounded them. They burned the roof. The defenders surrendered. The white force took roughly 50 black prisoners. That night, in groups of 5, they marched them into a field and executed them. By morning, around 150 black men were dead. 3 white men were dead. The federal government indicted 97 attackers. 3 were convicted. Then the case went to the Supreme Court. United States versus Cruikshank, 1876. Chief Justice Morrison Waite, writing for the court, ruled that the 14th Amendment protected black citizens only from state action, not from private mobs. The men who had executed prisoners at Colfax went free. That single ruling broke the federal government's power to prosecute white terrorism. It was not the only one. Slaughterhouse, 1873. Gutted the Privileges or Immunities Clause, Civil Rights Cases, 1883. Justice Bradley wrote that a freed slave must stop being, quote, the special favorite of the laws. Plessy versus Ferguson, 1896. Separate but equal. Justice Harlan, alone in dissent. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. Williams versus Mississippi, 1898. Poll taxes and literacy tests upheld. Black voter registration in Mississippi collapsed from over 130,000 to fewer than 9,000. A black newspaper editorial in 1883 said it plain, "The court has accomplished by law what the Klan accomplished by violence." 1877, disputed presidential election. Hayes versus Tilden. Republican negotiators met Southern Democrats at the Wormley House, a hotel owned, in a bitter irony, by a black businessman. The deal: Republicans would take the White House. In exchange, federal troops would leave the South. On April 10th, the troops left Columbia. On April 24th, they left New Orleans. The black-supported governments collapsed within days. Frederick Douglass said it. We gave them our votes in the peace. We gave them our loyalty in every election, and when they had used us, they traded us away for the presidency. We were the currency of the transaction. What followed was not the end of Reconstruction. What followed was 80 years of Jim Crow. Look at the pattern. A federal protection for black voting rights gets passed. A Supreme Court invents a doctrine to gut it. States rush to redraw their maps. Black political power evaporates. 1876. The court limits federal power to protect black voters from private violence. The Mississippi Plan goes nationwide. 2013. Shelby County versus Holder. The court ends federal preclearance under the Voting Rights Act. Within 24 hours, Texas implements a voter ID law, previously blocked as discriminatory. 2026, today. The court tells Louisiana it cannot draw a second majority black district. Within an hour, Florida passes a map projected to flip 4 seats. The Reconstruction amendments were not weak. They were betrayed by the same institution charged with enforcing them. Justice Harlan saw it in 1896. He said Plessy would prove as pernicious as Dred Scott. He was right. It took 58 years to overturn. We are now in year 1 of the next 80. W.E.B. Du Bois wrote in 1935, "The slave went free, stood a brief moment in the sun, then moved back again toward slavery." He was not writing about today. He was writing about 1877, but the sun moves the same way over the same country, and the people who built this republic on stolen labor have never stopped trying to take it back. The ballot was the hinge. They knew it then, they know it now. Read the book, know the playbook, recognize the hour.